Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. In our last episode of this continuing podcast series entitled Idaho versus Kohberger, we had notified you that the defense filed a motion for their penalty phase witnesses to be permitted to watch the guilt phase or the case in chief proceedings. If you have not had an opportunity to listen to that episode of our podcast, I do recommend that you do, because there's now been a stipulation that has been filed by the parties, the defense and the state. It is dated May 27th, 2025, and it is a stipulation asking the court to enter the order if the court determines that it is appropriate to do so. In other words, there will not be an objection filed by the state of Idaho to the defense's request. This document says, comes now, the state of Idaho by and through the Latah County prosecuting attorney and the above named defendant by and through his undersigned attorney of record, and hereby stipulate. That means agree to, ladies and gentlemen. Stipulate to the court excusing witnesses who will only be testifying during the penalty phase of the trial herein from exclusion during the guilt phase under IRE 615. That is the applicable rule of evidence. This applies only to contemplated penalty phase witnesses who are not also testifying during the guilt phase. This is dated the 27th of May, 2025. It's signed by William W. Thompson, Jr., prosecuting attorney on behalf of state of Idaho, Ann Taylor and Jay Logston's names are both here, defense counsel, but this appears to be just Ms. Taylor's signature. I believe that Mr. Logston's name was here because he is the author of the motion. So here we see both sides now asking the court to grant this relief. And just by way of background, the way that the trial is set up per the October 9th, 2024 court order is that it's going to be a bifurcated trial. It's going to start per the court order August 11th, 2025. That is when the case in chief begins. At that time, we anticipate there will be opening arguments from the state of Idaho, and then thereafter there will be possibly some opening arguments by the defense. Although the defense is not required to put on any type of a case, the defense can put on no case at all. But we have seen where it appears they want to put on at least a case for alternate perpetrators. That was something that has been filed by the defense. But in any event, the case in chief, the burden is upon the prosecution to prove every element of all 5 of the felonies that Mr. Kohberger is charged with by indictment, to which he is presumed not guilty at every stage of the proceedings until or unless a future jury of his peers adjudicate him guilty following the guilt phase of the trial, or he pleads guilty. If there is an adjudication of not guilty, everything ends. There will not be a second phase. There will not be a sentencing phase or a penalty phase, as it's called, of the trial. However, if there is a return of guilt, then matters will proceed into the sentencing phase. This is a capital case. The DP is on the table as a possible sentence. So this deals with just the mitigation witnesses who, in the event of a conviction, it is anticipated they would be looking to try to persuade the jury to implement a lesser sentence than the DP, is what the speculation is at this time. We will await Judge Hippler's order to see if he will enter or not enter this order granting this motion by the defense now that there has been a stipulation. Until next time, this is Kathy. Thank you for joining us today.